Hearing in the appeal of A1 Properties Limited against Tudor Studios RTM Company Limited.
Yes, Mr. Mays.
My Lord. Good morning, my Lords. May it please you, I appear on behalf of the appellant with Mr. Ronan. Mr. Jacob at the far end appears for the respondent, and Mr. Rainey, King's Counsel, and Mr. Loveday, sitting in the middle, appear for the intervener. In terms of timings, I have up to 2 hours this morning. Could be Counsel's famous last words, but I'm hoping not to need all of my 2 hours. Mr. Rainey has 30 minutes before lunch, come what may. Mr. Jacobs has an hour and a half after lunch, and I have 30 minutes for reply. May I start by setting out two factors through which I ask you to view the entirety of the submissions that I make this morning. These two overarching factors are as follows. The first is that the critical factual matter is that, contrary to the requirements of the 2002 Act, no claim notice was served on my client. And the reason why that matters is because it tells us what this case is not about. This is not a case about how we approach omissions or errors in the contents of notices. So this is not a case where the Manai line of authority is on reasonable recipient assists us. It's not a case where there's a substantially to the same effect provision in statute or in secondary legislation. And it's not a case about substantial compliance, because there was no compliance at all. The narrowness of what this case is about feeds into the second of the overarching factors I asked you to bear in mind. Because this isn't a case about construction of a document, because it's only a case about identifying Parliament's intention, the critical question to be asked on the appeal is the sine die question. What did Parliament intend the consequence of this failure to serve this notice under this Act to be? And that gives rise to the two grounds of appeal. The first ground of appeal starts and in many ways ends with the decision of the House of Lords in sine die. So I'll just wait for Lord Legate to be provided with power.
I'll do it. Thank you.
And on ground one, our submissions are that, in overview, our submissions are that where an Act requires a particular step to be taken, but doesn't specify the consequence of failing to take that step, the task of the court is to ascertain what Parliament intended. That is an assessment made on the usual principles of statutory interpretation, having regard to the section in particular that wasn't complied with, and the Act as a whole, and then the range of usual principles of statutory interpretation. And here I'll be praying in aid the context of the statute, that it's a private law statute governing the transfer of rights from one private party to another. And I'll be submitting to you that when you carry out that assessment of Parliament's intent using those principles of statutory interpretation, the proper conclusion to draw is that failure to serve a claim notice on a landlord contrary to section 79(6)(a) of the 2002 Act is that Parliament intended invalidity. To the extent the Court of Appeal decided differently in the Elim Court decision, it's wrong. The second ground of appeal is much narrower. The second ground of appeal starts from the premise that ground one has not found favour, and that there are circumstances in which a failure to serve a landlord wouldn't lead to invalidity. And on ground two, it's one very short point. Judge Cook in the upper tribunal found that, quote, the almost inescapable conclusion, end quote, was that this was a deliberate decision not to serve our client. And we respectfully say that in circumstances where someone makes a deliberate decision not to comply with a statutory requirement, Parliament would always intend invalidity. I don't want to spend any great time going through the background facts because, of course, you have the statement of facts and issues, page 49 in the hearing bundle. The only four that I can see being any relevance to this appeal are that we are a landlord under 4 leases of various common parts at this building. So we have a gym lease, a laundry room lease, a common room lease, etc. I accept I have no management functions under those leases. We weren't served with a claim notice in respect of any of those leases. And, as I've just indicated, the almost inescapable conclusion is that the failure to serve us with a claim notice was deliberate. And for your notes, it's just paragraphs 9, 11, and 20 of the Statement of Facts and Issues. My Lord.
Was that observation of the tribunal a judicial finding about a pleaded issue or just an off-the-cuff observation?
I'll take you to this in ground 2. It is a judicial finding of a pleaded issue. So before the FTT...
Don't do it now if you don't want to.
No,
I have that question at some stage.
I'll answer it now, but I'll answer it now and then take you to the material in ground 2. So before the first-tier tribunal, my case that I submitted to the tribunal was they should find it was deliberate. The FTT found that no, there were other reasons that could explain the failure. I appealed that to the upper tribunal, and Judge Cook agrees that on the only fair reading of the material is it was deliberate. That doesn't help me in the upper tribunal, because Judge Cook is bound by Elim Court to find that because there are no management functions, this is a failure that can be explored. So what's called ground 2 in the upper tribunal, I win on, but because I'd lost on ground 1, it took me nowhere. But I'll take you through that relatively briefly when we get to ground 2. But it's a finding of the only proper inference from the material. It's not a throwaway comment. My submissions are in 3 parts then. The first, I want to take you through the 2002 Act, and I'll identify in there the key provisions that I say are relevant to resolving this appeal. Secondly, I'll deal with ground 1, and then finally, I'll deal with ground 2. Can I start then with the 2002 Act itself, which in the hearing bundle, my note says it starts at page 296, and here is where we discover whether all the bundles marry up. Hopefully in the hearing bundle it should be page 296, both electronically and in hard copy.
Well, you're in luck so far as mine is concerned.
Part 2 of the Commonhold and Leasehold Reform Act 2002 introduces the right to manage. And as the court will know from having read the background material and from the Settlers Court case this court dealt with some 2 years or so ago, essentially it's a process by which qualifying leaseholders of flats in qualifying buildings can come together, form a company, and take over their freeholder or other managers' management of the building. Section 71 introduces the right. You see 71.1, a general introductory provision. Section 71.2, the rights are to be acquired and exercised subject to and in accordance with this chapter. The qualification conditions I'll take relatively briefly because they're not central to this appeal. It's sections 72 to 77. You see that section 72 introduces the buildings that qualify for the right to manage. 72.1, it applies to premises which are a self-contained building or part of a building, with or without a pertinent property. So conceptually, the standalone tower block would fall within it, as would an individual house within a terrace, potentially. It has to contain 2 or more flats held by qualifying tenants, so a leasehold house would be out, but otherwise it would be fine. And the total number of flats held by such tenants is not less than 2/3 of the total number of flats in the premises. So a landlord who had built, for example, a block they intended to rent primarily on short-hold tenancies wouldn't have much to worry about, but if they've granted long leases of more than 2/3 of the flats, then we have properties coming within here. Subsections 2, 3, all the way down to 5 add glosses to the self-contained building or part of a building test, Essentially, you're a self-contained building if you're structurally detached, and you're a self-contained part of a building if you are capable of being dealt with independently, because you can be divided from the rest of the terrace. Your structure is that you could be worked on independently, your service media independent, etc. Sections 73 and 74 deal with right to manage companies, which are the vehicle through which this right is claimed. You see in section 73(2), it's a private company limited by guarantee, and its articles of association, which we'll see in a moment, are prescribed, provide that its object or one of its objects is to acquire and exercise the right to manage the premises. Section 74 deals with who can join a right to manage company. 74(1)(a), the qualifying tenants of the flats, and then after the RTM is acquired, a landlord can join an RTM company. Sections 75 to 77 deal with who is a qualifying tenant. In simple terms, you are a qualifying tenant of a flat for these purposes if you hold the flat under a long lease. There are glosses on that simple definition. You look at 76(2), for example, a whole range of leases, some of which are more common than others, that are treated as long leases. The vast majority of people will fall within 76(2)(a). Your lease was granted for more than 21 years. The conventional definition of long lease used in most property statutes.
Yeah.
In terms of the process for claiming the right to manage, we now pay slightly greater attention to the statute. We start at section 78. So having formed your right to manage company, page 302, sorry. Having formed your right to manage company, you have to give a notice inviting participation, 78(1), to every qualifying tenant of a flat who isn't already a member or hasn't agreed to become a member. So it prevents, effectively, minority leaseholder rule. Everybody has to be given an opportunity, every leaseholder has to be given an opportunity to become involved. This notice, 78(2), is referred to as a notice of invitation to participate. And you see at 78(2) all the way down to 5, Parliament has prescribed the detail that must be given in that notice. So 78(2), for example, 2A, you have to state you intend to acquire the right to manage. You have to give the names of the members of the RTM company. You have to invite recipients to join the company. Such other details as are prescribed. Other details have been prescribed. They're not relevant to this appeal, but for your reference, the English prescribed material starts at page 365, and the Welsh prescribed material starts at page 382. Subsection 78(4), subsection 4 of section 78, you have to provide a copy of the Articles of Association or details of how to inspect and copy them with your notice. And 78(5) details how you can make those articles available to be inspected and copied. Over the page on 303, subsection 7, I do draw attention to and ask you to note, because I'll be coming back to this, to subsection 7 in ground 1. Section 78(7) provides that your notice of invitation to participate is not invalidated by any inaccuracy in any of the particulars required by or by virtue of this section. Now, I flag this as important because this is the first of a number of situations we'll see throughout the Act where Parliament has turned its mind to the inescapable fact that people will get things wrong, and has decided that those particular category of errors can be excused. Now, I accept, and I'll deal with this in ground 1, I accept this is about content rather than the giving of a notice, and having opened the appeal by asking you to remember that this isn't an appeal about content. But why it matters is because it shows you that Parliament has considered, A, is aware that human beings will get things wrong, and B, has turned its mind to the question of what kind of errors can be forgiven. It assists us in my submission, when I get to ground one, as to why other kind of errors are not to be treated so leniently.
Will you make an argument that it follows from this that other errors are not do invalidate?
So
that is a logically fallacious argument.
It all depends on the nature of the error. So in my submission, you deal with it this way. First thing you do is you identify the error in question. So in our case, it's the failure to serve the notice under section 79(6)(a). Then you ask yourself, what did Parliament intend? In answering that question, you have regard to the particular section that wasn't complied with and the scheme of the Act as a whole. I don't say that every error of every sort in every circumstance leads to invalidity.
But it obviously doesn't, because the Act says it doesn't.
But even if it didn't, because we'll come to this in Synergy, because what we're doing is imputing an intention to Parliament. What we're doing in that situation is we're looking at what's the admissible material to help us identify Parliament's intention. The primary admissible material for identifying Parliament's intention is the words of the statute in question. So where Parliament has identified errors which can be forgiven, but not, and has identified them by class or by description, however it may be, I do say it's a proper inference to draw that Parliament has intended other errors not to be forgivable. But that's not a complete answer.
It doesn't follow. Saying that a notice is not invalidated by a particular thing, all you can infer is that where it isn't identified in that way in the Act, the notice may be invalidated by the error, not that it must be.
I don't necessarily disagree with that at all. When we're coming to identify Parliament's intention, we're construing the Act as a whole. All I take from this provision is the very narrow point that Parliament has turned its mind to the fact that there will be errors and has identified which errors can be forgiven. That doesn't mean that when you come to impute the intention to Parliament in the language of Synergy, that there is no basis upon which any other error could ever be served. But it's how we approach this. It's in my submission, it's the logical rigour with how we approach this question. Parliament hasn't dealt with this scenario, so Synergy says we have to impute an intention. Where do we get the best evidence of Parliament's intention from? Well, you start with the words. You start with the words of the section and the word of the Act. And all I take from this is that it shows you Parliament is aware of the fact that people get things wrong and has turned its mind to what kind of errors could be served. That's not a knockout point, my lord, I accept.
Well, I'm just looking at paragraph 92 of your case, where you say that the logical conclusion is and can only be that other errors are fatal.
So
I'm just putting to you that is not a logical conclusion. It is that in the case of other errors, you simply cannot say that they are not fatal. They may or may not be.
So, my lord, when
these provisions tell you that certain errors will never be fatal.
So, my lord,
all you can infer is that other errors may or may not be. It may depend on the circumstances whether they're fatal.
So my lord, when we've completed our tour through the Act, my submission will be that the particular error in this case gives rise to invalidity, and I will be so bold as to submit that's the only proper conclusion that can be drawn. I don't go so far, and if I said this in writing, then I did go too far, as to say this one individual factor tells you that, because we're construing the Act as a whole when it comes to identifying Parliament's intent for this particular error.
I mean, it is just, before we leave section 78.7 for observation, actually section 78.7 is a rather extreme form of provision, because it's saying it doesn't matter how inaccurate
That's right.
Your notice is, that's not going to qualify as invalidity, whereas usually in a Synergy sort of situation it's going to be, if I can put it this way, slightly touchy-feely, exercise in working out whether it's a sufficiently serious failure to comply. So some will and some won't, whereas this is saying it doesn't matter how bad it is, it's not going to invalidate the notice.
Yes, I would agree with that. The point I seek to draw from it is the broader point, though, that Parliament has turned its mind to the fact that humans will get this wrong and has identified what the consequence will be, and it's not invalidity.
Right.
Now, the reason why that matters is because I do say that is a pointer towards other errors not being treated so forgivingly.
Well, you might say that where Parliament has wanted to answer that question, whether it will or will not necessarily be invalid, it's done so. And it's not included a provision saying that if you fail to serve a claim notice, for example, on somebody, then the whole proceeding is invalid.
And why isn't the inference that, if you like, the default then applies? If Parliament hasn't specified one way or the other, the default, by which I mean a synergy type approach, which I think you accept is the usual, why isn't that the approach to be inferred that Parliament intended should be applied? I'm not saying that gives the answer to the case, but it just means that you can't get very much from a provision like Section 78(7).
Well, I'm dealing with it now because it comes first in the Act, rather than because I want to make it central to my submission. In my submission, when I get there, the critical,
Fair enough.
the critical submission that I'm going to make, and I say my strongest point, flagging it up now, is actually going to be Section 79(7), the one that follows 79(6). Because 79(7), Parliament identifies the circumstances in which you don't have to serve a claim notice. And from that, I say the obvious inference is that in all of the circumstances you do, Parliament wouldn't create a scheme for avoiding the need to serve a claim notice if, in fact, you could choose not to serve a category of landlord identified by the Court of Appeal.
Well, that's obvious. We're told you have to serve a claim notice. The question is what happens if you don't.
Quite. And in order to ascertain Parliament's intent, the synergy process, you look at the Act as a whole. And hopefully, if I can finish taking you through the Act,
Yes, fair enough.
and then I'll drag you back to that.
Yeah.
The only point before leaving this, what paragraph is it? Don't worry about it. Let's move on then, if I may, to Section 79.
Yes.
The giving of the claim notice. You see, Section 79(1), the claim to acquire the right is made by giving the notice of the claim. So this is how the originating procedure, as it's sometimes called in some of the cases.
It's interesting, they don't use the word service, they use giving.
Yes.
And both then and again in subsection 6.
Yes.
Is that indicative of a slightly less rigidly legalistic requirement incorporating service-type baggage, or not?
I would say no. This court's decision in the... it's in the bundle, the decision about service of notice to bring buildings into the non-domestic rating list. And now I'll find it for you in reply in a moment, or my junior can find it. This court previously suggested that serve and give are in practice synonyms for the same purpose. It's to do, what you're concerned with is, does someone actually receive a document? Find it. Yes, it's the UKI Kingsway and Westminster City Council case, which is on page 481. It's the of the interveners bundle, I think it is. It's the first few paragraphs of that. From memory, it's Lord Carnworth who goes through the history of provisions on serve and give and concludes that in practice they're synonyms.
And sorry, that was page 481 of the interveners.
It's the interveners material, yes, although we may end up now discovering bundles are slightly different.
UKI.
So I've got it here. I've printed it off. I think there may be some. It is 481, Mr. Rainey.
Yes,
Help me.
I've got it.
So starting at 484, Lord Carnworth takes us through non-domestic billing legislation, and starting at paragraph 15 on page 486. Over onto page 487 at B, in soft brackets, no distinction is drawn in the cases between serving and giving a notice. See Kinchen-Bullard, see to similar effect to Deemer, a case under the Housing Act 1988. Serve is an ordinary English word connoting the delivery of document to a particular person.
Thank you.
So in section 79 then, the giving of the notice, section 79.1, you can't give it, section 79.2, unless you've given everyone who was required to be given the notice of invitation at least 14 days beforehand. Your claim notice has to comply with subsections 4 and 5, which is to do with having the requisite number of members of your company.
So to give this notice, you've got to give a notice of invitation to all people required.
Yes.
Conditional precedent.
Yes. So in terms of the procedure, the first thing you do is form your RTM company, because it's the company that has to give the notice inviting participation. It's the company that has to give the claim notice. You form your company. You then have to give notice of invitation inviting participation to every qualifying tenant who is not already a member or has not agreed to become a member. They have to be given at least 14 days to join your company before you can serve a claim notice. And you can't serve your claim notice anyway unless you comply with subsections 4 and 5, which is to do with having the requisite majority of leaseholders in your company. So if you are a building with only 2 flats, both of them have to have joined the RTM company, section 79.4. Otherwise, you have to have at least half of the qualifying tenants in your company. You then get to 79.6. The claim notice must be given to each person who, on the relevant date, is a landlord under a lease of the whole or part of any premises. That's us, and no one proposes that, no one suggests it was given to us. The other 2 categories of person who must be given the claim notice are people who are parties to the lease other than as landlord or tenant. So in the old cases, think of things like maintenance trustees. In a more modern world, tripartite management arrangements, tripartite companies, sometimes controlled by developers, sometimes by leaseholders.
And lease there is general, is it? I mean, it doesn't mean a long lease.
No.
So even a weekly tenancy would give rise to there being a landlord.
Yeah.
So a qualifying tenant could also be a landlord.
Potentially. The way you would deal with this if you were...
I know a qualifying tenant's got to be at the bottom of the long tenancy chain, but if he then grants a short tenancy, he'll also be a landlord, won't he?
Yes.
Yeah.
Yes. The way, as an RTM company, if you're worried about scenarios like that, if I jump ahead, then I'll come back to 79.6, is section 82 on page 306. Because section 82 gives an RTM company the right to give any person a notice requiring to provide the company with any information in his possession or control which they reasonably require for ascertaining the particulars required by or by virtue of section 80 to be included in a claim notice.
Yes.
So if you're worried about someone setting up a series of short unregistered leases, you'd use your section 82 rights to get the information you need.
Provided that has to go in the section 80 notice.
Yes.
And I take it that by virtue of section 80 includes the regulations made under section, the notes to the schedule and the additional bits and pieces in the regs.
Right.
But does the section 80 requirements well, we're going to come to them, but they don't include, do they, identifying who all the landlords are? And therefore I'm troubled as to how that how that information demanding process in 82 helps an RTM company find out who all the landlords are.
I would suggest quite a broad reading of how section 82(1)(b) operates. Although it's for ascertaining the particulars required by section 80, it's to be included in a claim notice for claiming to acquire the right to manage the premises. So what you're really driving at, I'd suggest, is the information you need to enable you to claim to acquire the right to manage the premises. But can I come back to that in a moment, because I'd like to carry on with section 79.6 for the moment. So section 79.6 is the three categories of person who must be served. The first is the landlord under the lease of the whole or part of any premises. The second is a party to a lease other than as landlord or tenant, so tripartite leases. And the third, managers appointed under the 1987 Act, which in simple terms are managers appointed by the first tier tribunal generally but not exclusively for fault on the part of an existing landlord. Subsection 7 is then also in my submission important to this appeal, because this is dealing with the scenario where you can't identify a landlord or they can't be found. So this may be part of my answer to my Lord's question.
Well, I've got a question about that. Does it include where you don't know there's a landlord there at all?
Well,
for example, take a qualifying tenant who has, unknown to you, granted a weekly tenancy and therefore has become a landlord. The weekly tenancy wouldn't be registered, and not clear to me at the moment how you could get information about that weekly tenancy exercising rights under 82.
If Section 82 doesn't help you, then I suggest the answer would be the first half of Section 79.7. Subsection 6 does not require the claim notice to a person who cannot be found or whose identity cannot be ascertained. Now, if you have no way of knowing that a weekly tenancy has been granted, because, as you say, it won't be registered because it's less than 7 years, and let us suppose Section 82 can't be used in the way I might suggest, then you'd have someone in my submission whose identity could not be ascertained. So you wouldn't have to serve.
But if you're right about what the scope of Section 82 is, then somebody has to go through the process, do they, of asking every qualifying tenant whether they've engaged in a short tenancy?
Well,
because they could have ascertained it, they could have done that, and so if they don't, that's fatal. The whole thing collapses.
Well, it depends. I'm identifying possible solutions to a range of scenarios where the individual facts might matter significantly. Because, again, I don't want to deviate too far from the facts of this case, but think, for example, of a very common form of covenant in long lease requiring you that before you sublet on your weekly tenancies, you have to have given the landlord notice of this. In that case, you could use your Section 82 provision to identify who it's going to be. Suppose the lease has no restriction on subletting, so that there wouldn't necessarily be an easy way of identifying whether there'd been any subletting at all, then Section 82 might not be the answer. So I appreciate the point my Lord's putting to me, because what my Lord is testing is, I think, is whether my construction leads to absurd scenarios or unfair scenarios, to which I simply say that the difficulty with this is you may need to know what each individual lease was saying to know which of the two that we've just seen different routes would be most applicable in your case, whether you could say it's a Section 79.7 first sentence case, or whether you'd say it's a Section 82 case. Sorry, my Lord Sales has...
It just seems to put quite a burden on the qualifying tenants if they have to, in effect, cover off all possibilities by the questions that they ask under Section 82 that might conceivably arise under the leases of other qualifying tenants.
And it may well be the better answer is that that's not someone whose identity can be ascertained under Section 79.7. It might well be the better answer is Lord Briggs's first position, that Section 82 possibly doesn't go as far as I suggest. I'm not necessarily trying to give you an answer to that, because it does seem to me that it would depend to some degree on what was happening in each individual lease situation. I take the point my Lord is making. This is not a scheme designed to have traps. It is not an obstacle course.
Right.
It's designed to flow through.
I'm just on this interaction between qualifying tenants possibly having let properties themselves, which don't appear on the register, and when you can ascertain that. Are you saying that there's some sort of threshold of notice that if you're somehow on notice that they might have done that, you then have to ask under Section 82?
No, I'm saying that an RTM company wanting to exercise the right to manage has to comply with the section 79(6)(a) duty.
Right.
How it does that depends in very large part on what lease structure it's dealing with in each individual case. Because the slightly unusual aspect of this case is that we're not a leaseholder of a flat, we've got a lease of a common parts. So, how do you deal with identifying the landlord under the lease who you have to give the notices to? There are at least 3 different solutions to that. First is, it may be that it's someone whose identity cannot be ascertained, because it may be that it is, to all practical purposes, impossible to identify the chain of subleases. It may be that Section 82 can be interpreted in such a way as to give you a right to require this information. And if the occupational leases require the freeholder to keep effectively a register of underletting, then that might be a route you want to go down. Or it might be that in this context, lease would be interpreted to mean long lease rather than any lease.
Does it even mean a written? I mean, is lease defined anywhere for this purpose?
Yes, towards the end of the definitional provisions. Yes, section 112, subsections 2 to 4 on page 329. Chapter lease and tenancy have the same meaning, and both expressions include, where the context permits, subleases or subtenancies or agreements for a lease or subtenancy, but don't include tenancies at will or at sufferance.
Right.
So they don't have to be in writing, is that right?
Oh, they don't have to be in writing, no.
They don't?
No, you can have an oral lease. But the question that I think is troubling the court at the moment, this started with a question about what does lease mean in 79(6).
Yes.
And the concern that it could include weekly tenancies, which then opens the door to the argument we've been having about how would you identify all of that.
Yeah.
And I've said there are three answers to that concern.
Yeah.
One is section 79(7) might be an answer, because it might be you can't identify the landlord under these subleases.
Are there any authorities on 79(7)?
No.
Is a weekly tenant a qualifying tenant?
No.
No.
Because to be a qualifying tenant, you have to hold a long lease.
So the landlord we're thinking about here is a landlord of a weekly tenancy.
For this scenario in this discussion, yes.
And that landlord would be a qualifying tenant.
Would be, yes.
Yeah. But he's also
Who has already been served with a notice.
In his capacity as qualifying tenant, yes.
The capacity as qualifying tenant. And there's no obligation then to serve the weekly tenant themselves.
No, because they can't join the company because they can't be qualifying tenants.
And they're not landlords.
Exactly, yes.
What about being parties under a lease? It's the party to such a lease.
Mm-hmm.
So why wouldn't the tenant under a weekly tenancy of a flat be party to such a lease?
Otherwise than as landlord.
Oh, he'd be a tenant, yes.
Yes, otherwise than as landlord.
Yes, no, fair point.
So what 79(6)(b) is catching is the modern tripartite lease with management companies, or if we go back
yes.
to the older days, maintenance trustees.
But it may be a rather wide net to catch.
Well, as I said,
mouse.
there's three answers to it, and which one depends, it seems to me, on what's actually happening on the ground.
Yeah.
The first answer might be 79.7. If you can't ascertain their identity, Parliament says you don't have to serve them at all. The second answer might be Section 82. And the third answer...
Well, can I just pick you up on that? Because it seems to me there's a bit of a tension between the point you're making on Section 79.7 and Section 82. Because if you say Section 82 is wide and then that enables people to ask questions, then what can be ascertained becomes very wide.
Yeah.
And that takes one back to the point that I was asking you before. It might be said to be very burdensome if someone knows that there might be categories of short leases. If they have to ask everyone who might possibly have granted such leases, well, did you or didn't you? And then they have to sort of almost ask a schedule of lots of different options. Anyway, you could deal with that.
To which I think the answer to that, the tension that my Lord Sales and Lord Leggett are pushing me on, part of the answer, I think, comes from what Lord Stevens just said. These... Go to section 112, where we just looked at the definition of lease. Page 329.
Yeah.
In this chapter, lease and tenancy have the same meaning, and both expressions include where the context permits. So it would be open to the court to say that the definition, that the lease that's referred to in 79.6a is the long lease, not the sublease or subtenancy. And one reason why one might say that is picking up on Lord Stevens' questions to me. The tenant under the weekly tenancy has no interest in this because he can't join the company. And the landlord under the weekly tenancy will be the tenant under the long lease.
But long lease is a term that's used in these provisions and it's not used here. I don't see how you can make lease mean long lease when...
It's
Don't say that.
because it's 1122. Lease and tenancy have the same meaning and include, where the context permits, sublease. So you simply say it doesn't include sublease.
I mean, it doesn't make it incoherent if it includes sublease. It just makes it more onerous.
Yeah.
And long lease is specifically used as a term when they want to refer to a long lease.
So it seems to me those are the three answers one can take from the Act as to what the answer might be to the problem that's being suggested to me.
Yeah.
It's either 79.7, or it's 82, or it's 1122.
Well, the fourth
can't be all of
answer
them.
is that you do have to do it, but in some cases where you have to do it but don't, it's not going to be fatal to the validity of the claim.
Well,
in other cases, it will be.
Well, and that begs the issue in the appeal. So if I can drag myself back to trying to go through the structure of the Act, I do place some weight on 79.7 because it actually does two things. The first is it doesn't require the claim notice to be given to a person who can't be found or whose identity cannot be ascertained. But secondly, if that means that there is no one to be given a claim notice, it creates an alternative procedure for claiming the right, which is in Section 85. Now, the reason why I say 79.7 is important is we come back to the Synergy question. What did Parliament intend the result to be if 79.6a wasn't complied with? That's the question we answer by looking at the Act as a whole. you get a very clear steer in my submission in 79.7 that Parliament has identified the two circumstances in which you don't have to comply with section 79.6a. You don't have to comply if you can't find someone or their identity can't be ascertained. And if that means there is no one to serve, you go to the tribunal under the alternative procedure. And the reason this matters...
Well, it doesn't... what it's doing is creating an exception. So you simply don't have to serve the claim notice. The obligation doesn't apply to people in these categories. It tells you nothing about what the consequence will be if you do have to serve a claim notice, but don't.
No, my lord, it does, because it tells you that Parliament has turned its mind to the scenarios in which a claim notice has not been provided, and it has identified the circumstances in which that won't be fatal.
No, it hasn't. It's told you when you don't have to serve a claim notice in the first place. Not whether it'll be fatal or not when you do, but don't serve a claim notice.
The effect of 79.7, in my respectful submission, when we see it in the context of the Act as a whole, it is identifying the circumstances in which 79.6a need not be complied with. I agree on that.
I thought you were moving at an earlier stage to accepting that in circumstances where a qualifying tenant who has sublet on a weekly basis, that would not be fatal because you are, in effect, those rights have already been dealt with. They have been protected because the qualifying tenant has had a notice. You don't have to serve the weekly tenant on any occasion. And so that lack of compliance, Parliament could not have intended that lack of compliance to be fatal to a valid notice being served.
So let me, I rather fear this is a situation I'd find myself in perhaps somewhat earlier than I was hoping for. I come back, and I will come back, I suspect, more than once over the course of my time, to what I say the answer, the question to be asked is, it's the synergy question. What did Parliament intend? And in these circumstances, where a landlord a landlord under a lease was not served, there's no question of 79.7 applying here. In circumstances where there's a failure to comply with 79.6 in respect of a landlord under a long lease, with no suggestion that this landlord was hidden or hard to find, etc., the outcome is invalidity. It is possible, I go no higher than that because I don't need to on this appeal in my respectful submission, it's possible that a different kind of answer might be reached in respect of the weekly tenant, either because they're not a landlord under a lease, because we could do 1122, or because 79.7 might save them, or because 82 might provide a route, or even because on the synergy analysis, on those different facts, Parliament intends a different outcome. But the reason I emphasise the narrowness of the facts at the beginning...
Well, we've just been testing your argument, and the last proposition you put forward is different from saying that which I thought you were seeking to maintain at one point, that where subsection 7 doesn't help you, then you're done.
I drag myself back again to the facts of this case. Synergy doesn't provide an answer to every single doesn't provide you an answer to every single case. It provides you an analytical framework to work out what the answer is. So we're asking ourselves, what did Parliament intend? This failure. And you don't necessarily answer that question in my submission, my Lord, by thinking about other failures, because other failures give rise to different factual considerations and possibly give rise to different arguments under different parts of the statute. We are dealing here with the cleanest possible form of non-compliance, a provision which says a notice must be given to my client and it was not given. 79.7 doesn't arise in this case. Its relevance, as with what I said about section 78.7, is that it shows you that Parliament has turned its mind to the kinds of problems, the kinds of failings that might arise, and has provided a solution. And the inference I ask you to draw, or the imputation of Parliament's intent I asked you to draw from that, is that where a detailed scheme has identified circumstances in which deviations will not be fatal, the proper inference is that other deviations will be.
I fear that takes us back to the debates that we had.
It does. It's the same fallacy. I think all it shows you is that other failures are not automatically exempted. They may or may not be fatal.
I mean, so I just wanted to put to you in the same point that I put on section 78.7, that section 79.7, in a sense, is quite extreme. It's saying this duty doesn't even apply if someone can't be found or their identity can't be ascertained. So you don't need to, in that situation, you don't need to worry about it at all. But that's rather, that just leaves open, doesn't it, the usual default position, which again, for default I mean the Synergy framework, that if you're not in these two categories of case, then you're in the Synergy framework. This doesn't give the answer to what happens when you're in the Synergy framework.
It gives you part of it. Synergy is not palm-tree justice. Synergy is an act of statutory interpretation.
All right.
So, we construe the Act as a whole, and we look for what pointers we can get from the Act as a whole. And what I ask you to take from the fact that Parliament's identified these two, we'll see there are two more in a moment, in total 4 different provisions. Having identified 4, I say the proper imputation from that, stay in the Synergy language rather than inference, the proper imputation is that other failings will be fatal. Now,
that's simply a fallacy. If the provision says the error will never be fatal, it doesn't follow that where you don't have such a provision, the error must be fatal. You just leave out the intermediate possibility that it may or may not be fatal, depending on the circumstances.
Well, and that's an element of the Synergy question. We come back to it. It's all Synergy. The answer to this entire appeal is Synergy. What does Parliament intend?
Well, of course, that itself is just tells you nothing to us, put it that way.
Well, no, it does, because Synergy gives us the analytical framework. Synergy tells us that this is an act of interpretation. We'll look at Synergy in a moment, but Synergy tells us it's an act of interpretation where we are imputing an intention to Parliament that Parliament of necessity did not have, because it would have said something if it had turned its mind to this. So we're having to extract Parliament's intention from the material that we have.
Well, on that, can I ask you this? Might it not be said that section 79.7 actually cuts against you on the Synergy question, because it shows that Parliament contemplates that there will be situations where people are affected by what is going to be done under this procedure, but are not served a notice, and yet it contemplates that the procedure can go on, at least in those circumstances, and it's only in one situation where you can't find anyone at all that you have the separate Section 85 requirement.
So that was one of Lord Justice Lewison's points, of course, in Ealing Court, which taken against me all those years ago. The answer to that, which I wish I'd thought of, I suggest back in 2017, the answer is that it's the narrowness of subsection 7 that's critical. The point you put to me, my Lord, is Lord Justice Lewison's one, which is, well, look, having identified the fact that it won't be critical in some circumstances, can't I extrapolate from that Parliament didn't necessarily intend the claim notice to be quite as central as I'm submitting? To which the answer is no. It's the narrowness of the exception that shows you how central the claim notice is. The only circumstance where you're exempted from complying with 79.6 is in respect of a person who can't be found or whose identity can't be ascertained. And then if that means there's no one, there's the bespoke procedure by applying to the tribunal. That's not authority for the proposition that Parliament somehow treats claim notices as of secondary importance. That's identifying the very narrow circumstance in which what is on the face of it, unqualified duty in 79.6 can be watered down. Can I just carry on? Because I'm happy to do it in this way, but of course this is most of what's in ground one. And having told my lords that there are 4 provisions that are of particular relevance, there are the other 2 I'd like to take you to before we get to the full argument. In section 80, of course, we're dealing with the content of the claim notice. As with the notice inviting participation, you'll see Parliament's prescribed a fairly detailed content from subsection 2, which is identifying the premises, all the way down in 3, the people who are members of the company, details of their lease, details of the RTM company's name and registered office, the date for the giving of the counter notice, the date by which it is anticipated right to manage would be acquired, and such other particulars and in such form as may be prescribed. Again, we've got the prescribed forms in the bundle. I don't need to take you to them. Section 81 contains the last 2 saving provisions.
I'm terribly sorry to take you out of your course, but I just had a question on section 79.8.
Yes.
A copy of the claim notice must be given to each person who on the relevant date is the qualifying tenant. Yeah. So what happens if that doesn't happen? Is the procedure then defunct?
The argument would turn upon, on a synergy interpretation, is there a difference between the claim notice and a copy of the claim notice? And it may be there is a difference.
Yes, I see that.
It may be there is a difference, because if you go to section 84.1, which is on page 307, it's only the people who were given the claim notice under 79.6 who can serve counter notices. So a qualifying tenant who receives his copy of a claim notice has no right to do anything with it. So if we were in that world of a copy of a claim notice not having been given to a qualifying tenant, I fully see an argument based in synergy that wouldn't lead to invalidity, because the scheme of the Act as a whole, there's no next step after that person gets that copy of a notice. They can't do anything with it.
And what if that was a deliberate omission? You know you have to do it and you don't.
Well, that then, again, it comes back to the synergy question. If I do suggest then that it would be very difficult to say that a deliberate, by which I mean bad faith, decision could ever be something that Parliament could be taken to have intended wouldn't lead to invalidity. When we do synergy, we'll look at the Clydeside case quoted in it. The Parliament expects its instructions to be obeyed to the most minute detail.
Okay.
So that may be a different scenario.
Yes, thank you very much.
I'm sorry to bring you back to 79.6a. We were looking at a qualifying tenant who was also a landlord under a short lease. Yep. But as a qualifying tenant, he receives a notice asking him to join. He's got no rights to serve a counter notice. He's got no rights to say, by the way, you're not a proper RTM company.
No.
So And he would own the qualifying tenant, who is also a landlord, would have a right to serve a counter notice and to object.
A person who receives a claim notice under 79.6 has a right to serve a counter notice, but it's only those category of people in 79.6 who have that right.
And that all hangs on the words copy of in subsection 8, does it?
No, it's 2 points. The first is that subsection 8 speaks of a copy of the claim notice rather than the claim notice.
Well, that's the point I was putting to you.
But the second freestanding point is that the notice served under 79.8 doesn't actually give you any subsequent rights, because it's only the people who get the notice under 79.6 who can serve a counter notice.
Why?
So you're a qualifying tenant sitting in your flat. You may or may not be a member of the RTM company as well, but in your capacity as a qualifying tenant, you get your copy of the claim notice. You can do nothing with it. You have no right to serve a counter notice. It is a purely for information provision. And that's why, picking up on my Lord Sales' question, I can foresee that Synergy might give rise to a different answer.
But if you're a qualifying tenant and a landlord, you're entitled to get the claim notice and a copy of it. And if you get the claim notice, you can serve a counter notice.
Possibly. It comes back again to the question, to the discussion we were having 10 minutes ago about the meaning of lease and whether 112 could be read as limiting to long leases. Yeah. But yes, conceivably.
And then you would have to apply Sanjay to say that if you were a qualifying tenant and a landlord of a short tenancy, that Parliament didn't intend the failure to serve a notice on you to be fatal.
That may well be an answer in that context as well. It's why I stressed at the beginning, the overarching point I asked you to keep in mind throughout our submissions, is that no one served us at all.
Because the qualifying tenant hasn't got a right to object to serve a counter notice, and the short tenant hasn't got any rights at all.
Exactly. It's the narrowness of, it's the starkness rather of the facts that I say actually make this a relatively straightforward appeal. Because the more difficult scenarios, the more difficult applications of synergy are the ones you're putting to me, where people have got something by some route or another, query what the point of serving them in the first place was. We're not that territory. We are entitled to this, we'll come into what we lose, but we're entitled to this notice. We're not within the category of persons that Parliament provided did not have to be served. We're not within those circumstances. We say the proper interpretation is invalidity.
And so far we've been talking about an example where a qualifying tenant grants a short lease to a subtenant. Presumably you could have a chain of short leases. Is that right?
That would be lawful, yes.
And if you did, Section 79, subject to your point about it just applying to long leases, would apply to every short lease landlord in that chain, is that right?
Conceivably, yes.
Yeah.
If landlord under a lease means every landlord under every form of lease, then yes.
Yeah, okay.
And every party to such a lease.
Other than as landlord or tenant.
Other than as landlord or tenant. So guarantor, for example.
Conceivably, that's the only even remotely likely third party to a short lease, yes.
I mean, the thing that sort of stands out from looking at 79.6, one gets the impression that Parliament thought that the RTM company would always have on its desk a complete stack of all relevant leases. So you just go through the stack, identify the landlords and the other parties, and send them a claim notice. But that's, I mean, if you're talking about long leases, that might be true because they'd all be registered.
Yes. And that might well be, although I put it as the third of the three options, that might well be the words in 1122, unless the context so permits, which drive us back to exclude short subleases. But yes, I agree, my Lord. Parliament, I agree. The natural reading of this is Parliament envisaged someone went along to the land registry, paid their £3 fee,
got all the leases,
printed off everything they needed.
Yeah.
Yes, I agree. Can I carry on then with Section 81, because Section 81's 1 and 2 are the last of the two saving provisions. 81.1 is the mirror to what's in 78.7. So just as you'll notice inviting participation is not invalidated by an error in the particulars, an inaccuracy, in the particulars, nor is your claim notice invalidated by an inaccuracy in the particulars. And then 82.2 is a scenario where you've inadvertently included in your claim notice someone who wasn't a qualifying tenant of a flat. And in those circumstances, you disregard that person, but your notice is nonetheless valid so long as the remainder of the names take you over the threshold required by sections 79.4 and 5.
That's to avoid inflating your claim by people who aren't qualifying tenants.
It could be for any number of reasons. It could be to avoid that. It could just be simple error. It could be that you've failed to catch up with the fact there's been an assignment. You may have referred to the outgoing leaseholder by mistake. But again, what I say you get from those, from 81.1 and 81.1 and 81.2, is Parliament again turning its mind to scenarios in which failures to comply with its detailed requirements will not be taken to give rise to invalidity. And I do say that you can fairly take from that Parliament has turned its mind to the question of which errors should be excused and which errors should not.
But again, if I may,
same point again.
One could put it in a different way and say Parliament has turned its mind to some problems.
It said that certain errors will always be excused, but it hasn't told you which errors will never be excused, or whether there are such errors.
And I mean, basically, looking at this, we already know there are other problems that it hasn't turned its mind to. I mean, as Lord Briggs says, one reads section 79.6 and the impression you get is it's all tickety-boo. You've got a full stack of leases in front of you and you work through them, but the real world isn't like that.
When I come to ground one, I'll be suggesting there are three reasons why Parliament intends invalidity, of which the first is what I've just taken you through. Yes. But there are others, all emerging from the phrasing of the Act, and other parts of the Act giving you other indicia. I don't stand here and say that any one of the factors I've identified this morning is the knockout point that makes it clear beyond any doubt what we should infer Parliament's intention was. My ground one, when I get there, is hopefully works as a cumulative analysis across the Act as a whole. And if I can then just carry on through the Act itself,
and just so I'm clear, is that the end of your four? Those
are the four statutory saving provisions in there.
I just wanted to check.
I still need to carry on with a bit more of the Act. Course, I need to deal with the counter notice, and I need to deal with the rights that are acquired, because it's not as simple as the Court of Appeal said in Elim Court that it's only the management functions under leases that are lost. I want to try and show you the full picture of what is lost when an RTM goes through. So can I jump ahead then to section 84 and counter notices? We've looked at section 84.1 already. The right to give a counter notice is only a right that belongs to someone who is given a claim notice under section 79.6. So if you're not given the notice, you have no right to have the counter notice. So in my case, of course, my client didn't receive the claim notice, so we had no right to give a counter notice. We only got a right to join the tribunal proceedings because the management company to one of the other leases served a counter notice, so there had to be a hearing, and we could be joined in the usual way. But in my submission, what you take from 84.1 is it's the starting point of what I'm going to call the centrality of the claim notice. Because without it, the recipient simply can't, as of right, access the remainder of this Act. It's pure happenstance whether they get to be in front of a tribunal without a claim notice, depending on what some other landlord might do.
Is the tribunal's jurisdiction that restricted? What if no counter notices were served, but nonetheless you come to the court and say, well, that may be so, but I wasn't served with a claim notice, therefore the procedure was not validly undertaken, and therefore RTM Co's attempt to take over the levers of management from Management Co is invalid.
So you can't say that in the first tier tribunal, because section 84.3 is the tribunal's jurisdiction under these proceedings. Where the RTM company is given a counter notice which contains a statement, as in 2b, i.e. a statement denying the right to manage, then the RTM company applies to the appropriate tribunal, FTT in England, LVT in Wales, for a determination on the relevant date it was entitled to acquire the right to manage. Absent a negative counter notice, you can't go to the FTT. Now, there have been cases where none, as far as I'm aware, reported, just as aware from my...
Sorry, just
my Lord,
on
sorry,
that,
yes.
if you learn later that the RTM company, or you want to say, you weren't served, and you want to say the RTM company actually wasn't entitled to acquire the right to manage.
There's nothing in this Act that lets you make that application to the tribunal. The only way you get in front of the tribunal under this Act is if you're given a claim notice, you serve a negative counter notice, and the RTM company then applies under 84.3. It doesn't have an open-ended declaratory jurisdiction.
But presumably the High Court does.
I was going to say, my Lord, that there have been cases...
But the difficulty about that is that if there is no counter notice served at all, then there is an immediate acquisition of rights.
Right.
And the question then arises, to whom does the tenant pay the charges, which contractor has contracts, and all that's got to await the outcome of some High Court action.
Quite.
And,
or you end up with satellite litigation in the county court where someone sues for service charge arrears and the tenant says, but I paid the RTM company. So the High Court, whether you end up with a declaration in the High Court or satellite in the county court, but thoroughly unacceptable, I agree.
when one's thinking of third parties' rights, one's thinking of the rights of all the tenants in the block of flats. And the contractors who are actually doing the work, whose contract come to an end. Is that right?
No. Under the Act, you have to serve a contract notice on them telling them the RTM company has taken over. What happens then depends on the individual contractual position. In some cases, you might find it's frustrated. In some, you might find it's novated in some, you may find a wholly new contract is agreed. The Act, again, it's one of the well-known flaws in this Act. The Act simply provides for contractors to be told there's been an RTM company appointed. Nothing actually happens. It doesn't grapple with the difficulty of who they're providing the services to. Just picking up on my Lord's point about High Court inherent jurisdiction declarations, or my additional point about the county court, this is presently something, you may have seen the Leasehold and Freehold Reform Bill is presently going through Parliament. One of the proposals it proposes to make is to take away the High Court's first instance jurisdiction in relation to RTM claims. So it seems that even the residual option of going to the High Court for declarations that you were not an RTM company will not be available. This is not a problem that occurs under the Leasehold Reform Housing and Urban Development Act 1993, on which much of this legislation is based, the enfranchisement provisions. Because under enfranchisement, if someone doesn't serve the notices, you still have to go to the county court to prove your entitlement. So if you serve it on a building that just doesn't qualify, London Zoo is the textbook example. You serve it on London Zoo, they ignore your claim because they're London Zoo. You turn up in the Central London County Court and you'll be dismissed because it's not a building to which the Act applies. You don't have that safeguard here. The way this Act works is if no counter notice is served, you acquire the right to manage on the date specified in your notice. It's why the claim notice is so central to this, because there isn't another safeguard built in.
Right.
So what is the, if you never learn about it because you weren't served by a notice, served with a notice when you should have been, so no counter notice is served, so the rights are automatically acquired, then what do you do?
At present, you go to
the High Court at the
yes,
moment, do you?
at present.
Seek a declaration that it was invalidly acquired because the notice wasn't served.
At present, that will be the best advice given. I'm not aware of anything being reported, but there are High Court cases where that has happened. Or you end up with satellite litigation in the county court.
Yeah, when somebody tries to act on it.
And some poor county court judge has to unravel all this to work out where the service charge money should have gone.
But in the meantime, people can't enforce covenants because they don't know who's got the ability to enforce the covenants.
Quite.
And you don't know to whom to pay the service charge, and you don't know which the contractors, who they have to contract with.
Quite. And as I said 10 minutes ago, in my ground one submissions, I want to build this in stages. I do rely upon, despite what my Lord Legate's doubts about this, but I do rely upon those saving provisions to give you an indication. But my second point when I come to ground one will be the centrality of the claim notice to the proper working of the scheme. Absent the claim notice, a whole myriad of additional problems arise. It's why, in my respectful submission, you can understand why Section 85 has been created. Remember, Section 85 is what applies where there's no one you can give a claim notice to. It's the second half of Section 79(7). You don't have to give a notice to someone you can't identify or locate, and if that means there's no one, you go to Section 85. And what Section 85 provides for is an application to the tribunal. The tribunal will require you to take such further steps by way of advertisement or otherwise as is determined proper for the purposes of tracing people who should have received claim notices. So in the usual way, adverts in the local press, etc. And at the end of that process, if no one has come forward, you acquire the right to manage. So you'll have a tribunal decision.
Can you just remind me, where is the provision that says what the consequence is if no counter notice is served? Or are you just straight back to the beginning of the...
No. It's in Section 90, acquisition date.
90?
Yeah, 90, my Lord, yes.
Yeah, thank you.
So it turns on subsection 2, because you have to decide whether there's been a dispute about entitlement. If there's no dispute about entitlement, you get the RTM on the date you specified in your notice, that's subsection 2. And there's no dispute if no counter notice is given, or if a positive counter notice is given. That's 90 subsection 3. If you acquire it, 90 subsection 4, as a result of a tribunal decision, you get it 3 months after the decision becomes final. So the problem is section 90 subsection 3A. If no counter notice is given, you get the right to manage on the date in your claim notice.
Because there's a statutory non-dispute.
Yes. Statute deems
Even if there's a very angry person who says he should have been served with a claim notice, wanting to go to the European Court of Human Rights, there is still a statutory non-dispute for the purposes of this machinery.
Statute says there is no dispute about entitlement in the conditions to which section 90 subsection 3 apply.
I suppose you've got to have served at least one claim notice, otherwise you haven't engaged the machinery at all.
Yes, because if you didn't need to give any claim notices because there was no one at all, you had to use section 85 and the tribunal provided for the acquisition under that route, yes. Yes, that's right, my lord. Just carrying on
How do third parties' rights play out further down the line, as it were? Insofar as if you have no counter notice because the people who have been served aren't interested in serving a counter notice, and the person who is interested didn't receive one, how does that impact on the tenant's rights, the landlord's rights, and so on. If you assign the premises or assign property rights.
So in this scenario, my lord, you've served a claim notice. The landlord received it and was perfectly happy for the right to manage to be acquired, so elected not to serve a counter notice.
Yes, but there was a failure to serve an intermediate landlord. And therefore, the intermediate landlord wasn't in a position to serve a counter notice. Therefore, there was an acquisition of the right to manage.
So that of course, is
including the right to enforce covenants.
So that, of course, is a slightly different factual variation on the present one, but gets you back to the same problem.
Yeah.
What's the consequence of failure to comply with Section 79(6)(a)?
My question was more directed at what is the impact on third-party rights after assignment.
Well, third parties find themselves, I suspect, in an invidious position because they're not to know about the Section 79(6)(a) problem. Again, we're now moving into the realms of an answer that I suspect won't meet with much favour, but I suspect it depends. You could imagine a situation where a contractor was contracting with the RTM company, perfectly willing to provide the services, was providing them. If an intermediate landlord comes along and says, well, you're not a right to manage company, you shouldn't be doing this, I suspect the contractor would turn around and say, this isn't my problem, that's between me and the RTM company, I have a valid contract, you're going to pay me under it. The RTM company might have a problem raising funds from the service charges, but the contractor would simply say, your difficulty vis-a-vis your building doesn't impact on my contract. You could equally imagine factual scenarios where it's rather more important that the one, frankly, that always terrifies me is insurance. Because if it turns out you had no right to replace the insurance for the building and a disaster happens, do you find yourself in a situation where an insurer can avoid the contract? And the short answer, my lord, is there isn't one answer. This has come up, these problems, from time to time in the context of the 2002 Act. I suspect across the four council sitting to my left, myself and three councils sitting to my left, we've covered most of them. There isn't anything I can take you to, High Court or above, that's a principled analysis. People have muddled through with varying degrees of success, is the short answer. Having looked at Section 85, I just want to do Section 88, and then I'll turn to the rights that are acquired. Section 88 is concerned with costs. I just ask you to note Section 88(1). RTM companies are liable for the reasonable in costs incurred by the three categories of person who should receive a claim notice in consequence of a claim notice given in relation to the premises. So there's a linkage between the giving of the claim notice and an entitlement to recover certain legal costs. And then the substantive rights that are acquired, Section 90 deals with when you acquire the right. We've looked at that already. The rights that are acquired, Section 96 is probably a good place to start, because this is the provision that's been most relied upon in the Elim Court decision. The RTM company, it's at page 318, Section 96. The RTM company acquires management functions relating to the whole or the part of the premises. And management functions, whether they're functions of a landlord or functions of a third party to the lease, become functions of the RTM company. Management functions are defined in subsection 5 as services as in respect to services, repairs, maintenance, improvements, insurance, and management. And as we identify in our written case, the simplest way to think of those is that's the service charge functions, because that's the first half of the definition of a service charge in the Landlord and Tenant Act 1985. But it's not limited to service charge functions. It's management functions as defined, and then as supplemented by paragraphs 97 and following. So at 97, subsection 2 kicks in to prohibit a landlord from exercising any powers which now vest in the RTM company by virtue of section 96, unless an agreement is reached to the contrary with the RTM company. Subsections 98 and 99 deal with approvals under long leases, that they are unnecessarily complex provisions. The way they work is that the RTM company can now give approval under leases, but it's not an unfettered power. In the case of approvals relating to assignments, underlettings, charging, parting with possession, structural alterations, improvements, or alterations of use, they have to give 30 days prior notice to the landlord. That's section 98, subsection 4. In all other cases, they have to give 14 days notice. And the RTM company can only grant approval if the landlord also grants approval or doesn't reply within that period of time. Sections 98 to 99. So they don't acquire exclusive control over consents, but they acquire a role in consents under leases.
Sorry, just as we were looking at 97.2, I was just checking that 97.2 seems to marry up with section 79.6. That's
Yes.
the same
It is, yes.
category.
So
And I just wonder whether an inference from what's happening under sections 96 and 97, which is the transfer of the management functions, it tends to indicate that the intention is to sweep up every lease, so that you're not left with some landlords with management functions in the chain, but others not. It's every landlord with management functions gets transferred over to the RTM. And the reason I raise that is that seems to be a point against your third way through of suggesting that in section 79.6 it's just talking about long leases. I wonder actually whether the structure indicates that it is intended to be all leases, as it seems to say.
I think that's probably a fair description of what section 97 is doing. It comes back to what weight you could place upon the words in brackets in 112, unless the context so requires.
Right, but I was putting to you an additional contextual reason why one might think that actually it is all leases which are intended to be covered, so that you're sweeping up all management functions and giving it to the RTM. Anyway, I just wondered if you had anything to say.
No, I think that's probably right, is the answer. I appreciate that. I wish I had a better answer, but I think that probably is right. Section 100, enforcement of tenant covenants. So, returning to a theme my Lord Stevens has been concerned about. The RTM company acquires the right to enforce what are called untransferred covenants. So an example here is a nuisance covenant. The RTM company is entitled to enforce a don't commit nuisance covenant in the same way that a landlord could. The only exception is 100 sub 3. It can't exercise any right of re-entry or forfeiture. But of course, as it owns no residual interest in land, it couldn't have forfeited anyway. And then section 102, a series of statutes are amended once an RTM company is in place. And if we can go to Schedule 7, which is on page 335, you'll see the range of statutory modifications that take place. Most of these are...
So sorry, could you give me that page number?
335 is where Schedule 7 starts.
Thank you.
The text of the paragraphs is on 336. So most of these are fairly self-explanatory because they're ensuring the RTM company is in the same position as a landlord. So just as landlords can't unreasonably withhold consent, nor can RTM companies. Look at paragraph 1. Just as landlords have to repair under the Defective Premises Act, so do RTM companies, paragraph 2. It's not, though, limited to that. So if we look at paragraph 10, for example, on page 341, the RTM company acquires the right to apply to the first-tier tribunal to vary the terms of leases in buildings which they are the RTM company in relation to. And those 4 provisions there cover applications to vary both where there's some particular kind of defect in the lease. Service charges don't add up to 100% is the most common one. But also scenarios where you can find qualified majority support for a variation even if there isn't a particular problem that needs to be varied, section 38. So it's not as simple as saying, well, of course, all these statutes that make landlords repair or make them keep their service charges in bank accounts, those apply to RTM companies as well. They acquire quite significant rights, possibly to make lasting changes to the structure of the leases at the building. And so what I ask you to take from that overview of the rights they acquire is that the RTM has implications far beyond just management functions under leases. It goes to approvals, it goes to enforcement of covenants, it goes to the operation of statutes, it goes to possibly changing the terms of leases. So, with that overview, can I then turn to ground 1 and why I say a failure to comply with section 79(6)(a) on the facts of this case give rise to invalidity. And as I've indicated already, the only case I place weight on is Synergy. There are a vast number of cases that across all 3 parties we've cited, and I'm not going to deal with any of them apart from Synergy, and there are 3 reasons for that. The first is time, because of course I would be here all day if I tried to do all 30-odd we've cited. Secondly, without wanting to be overbroad on this, the vast majority are irrelevant. It's the Synergy question. What did Parliament intend? And glossing that by what the upper tribunal or the Court of Appeal thought about different statutes doesn't take us anywhere. And thirdly, again returning to where I opened this appeal, most of the cases are answering a different question. This is a case where no notice was served at all. Cases where notices have been served, but some particular detail has been omitted, don't help you with cases where nothing was served. Because where a notice has been served, you have additional questions before you get to Synergy. Where a notice has been served, and there's some problem with it, you start with man-I. Can you just construe it so that it's valid, notwithstanding the apparent problem?
Well, that probably may not take you very far.
No, quite. It's why I say none of these really help. Secondly, as we've seen when our canvassing through the Act, it's very common for Parliament to identify errors in notices that can be forgiven. We've seen 2 examples in here. In our annex to our written case, we've identified some others from the landlord and tenant context. A statutory saving clause of some provision is often quite common. And if you're operating that, you aren't getting to the Synergy question because you've got a valid notice because it's been saved in accordance with the Act. So cases about notices and the content or interpretation or construction of those notices don't take us anywhere. We are Synergy, and if I can take you to page 665. The context is obviously quite different from criminal confiscation proceedings, But for our purposes, we say all the relevant law you need is page 674, paragraph 14, through to page 678, paragraph 23. It's an analysis of the previous cases, both domestically and across the Commonwealth. I won't read all of that to you. I'd ask you to read that. That is all you need for history, and it's all you need for what we're doing today. But I do just want to draw out a handful of points from those provisions. The first is at page 675G. In Synergy, quoting now Lord Slynn giving the judgment to the Privy Council in Wang, Lord Slynn identifies there being two questions. The first is whether the legislature intended the person making the determination to comply with the time provision, whether a fixed or reasonable time. If so, did the legislator intend a failure to comply with the time provision would deprive the decision maker of jurisdiction and render any decision which he purported to make null and void. That's obviously the facts of that case, but the two stages are right. The first thing you do is construe the Act. So what did section 79(6)(a) require? Then you move to the next question. If it wasn't complied with, what did Parliament intend the consequences to be? And the answer to that is page 678, paragraph 23, relying on Attorney General's reference number 3. You're focusing on the consequences of non-compliance. You're asking whether Parliament fairly intended invalidity, but this is ultimately a question of statutory construction. It is, however, a slightly unusual form of statutory construction for the reason given at 675, paragraph C. Starting in framing the question this way, it's necessary to have regard to the fact that Parliament ex hypothesi did not consider the point of ultimate outcome. Inevitably, one must be considering objectively what intention should be imputed to Parliament. So we're engaged in a task of statutory construction, and we are asking ourselves what intention should be imputed to Parliament, having regard in particular to the consequences that flow from the failure to comply. So if we apply synergy to this case, well, what's the scope of the obligation? 79(6)(a), it is to give a notice to a landlord under a lease. That is us. Was it complied with? No. So what are the consequences? And we say there are 3 reasons for invalidity. And these have, to a large extent, been foreshadowed in earlier submissions. But reason 1 for invalidity is the language of section 79 itself. Section 79(6)(a) is in clear and unequivocal terms. It must be given to that category of landlord. The exceptions are identified in 79(7). And any other interpretation leading to...
My problem with this is still that it's answering Lord Slynn's first question and not the second question.
Well, the second question of Lord Slynn is my reason 3, the centrality of the claim notice. So I say three reasons for invalidity, but the reason, respectfully, my Lord, you do start with defining the scope of the obligation is because we're told this is an act of statutory construction. So we need to understand what was supposed to happen. And in identifying...
That's the starting point.
Yes.
But the actual relevant question of statutory construction is what is the consequence of non-compliance, and that's what we're concerned with. And
Yes.
looking at what compliance requires doesn't help with that second question. It's just the premise which leads you to ask the second question.
It helps to this extent. It helps to the extent that once Parliament has identified circumstances in which one does not need to comply with the primary obligation, here the section 79(7) point.
Well, another way of putting it, there isn't a primary obligation.
I'm happy to put it that way. What it shows you is that Parliament has turned its mind to the circumstances in which the clear words of 79(6)(a) don't need to be met. And
it hasn't. It's just said that the clear words of the scope of the section doesn't extend to that case. It doesn't say that when it does extend to the case, you don't have to, it tells you what's going to happen.
My Lord, if I may, it's two different ways of putting the same point. The point I stress is that we know that Parliament has considered, in the broadest terms, circumstances in which a claim notice need not be given. That's what we can take from 79(7) being in the Act. We are now, in identifying what Parliament intended, engaged in an act of statutory construction. The fact that Parliament has identified some circumstances in which its apparently clear words do not have the effect that they would have absent 79(7) is a relevant factor in identifying Parliament's intent. So I said there are three reasons for invalidity. The first is the language of section 79 itself. 79(6)(a) is clear. 79(7) is relevant because it shows you that Parliament has considered when those clear words need not be complied with. And any other interpretation of section 79(6)(a) in my submission either dilutes the clear words or, as Judge Cook put it, amounts to writing in an exception which is not there. It writes to writing in an exception that 79(6)(a) need not be complied with in respect of a landlord with no management function.
But that's almost like saying, don't do sonergy, because whenever sonergy leads to the conclusion that the consequence isn't invalidity, in a sense, you've diluted the primary obligation. But that's Lord Slynn's two-stage process gets you away from that.
But it's what we're inferring into Parliament. It's what we're inferring. The reason for going to that paragraph about inferring an intention to Parliament, which quite plainly they did not, in a circumstance they did not consider. This is a very special form of statutory interpretation.
Not really. It happens almost every case we get where there's a question of statutory interpretation. Parliament probably didn't think about it, and we've got to make some sense of the legislation.
But there's a difference between construing words and deciding what they mean, and deciding what Parliament intended a consequence to be. And what I do respectfully suggest is that in circumstances where Parliament identifies a duty, Parliament expects that to be complied with. See, for example, the quote from London and Clydeside at 674 in the authorities bundle. So we are interpreting against a background where you're being asked to decide whether Parliament intends invalidity in these circumstances, and what Parliament is doing, what you're doing in that case, I suggest, you should be very cautious. You should err towards invalidity, because anything else takes you down the route of diluting the words or writing in exceptions that are not there. We get the answer to what Parliament intended primarily from the statute itself. That's why I've been labouring the fact that Parliament has identified circumstances which will not give rise to invalidity.
Well, the first thing to do is to identify what the purpose of the statute is. Yeah. And so what do you say the purpose of this legislation is?
The purpose of giving the claim notice is my reason 3, if I can come on to that. Yeah. So reason 1 is I say you get this from section 79.
We know reason 1 very well now. I'm quite interested to know your reasons 2 and 3.
I'm not sure there can be any doubt as to what my reason 1 is. Whether it finds favour is another matter. Reason 2, the language of the wider Act. And this is where I took you to section 78(7), 81.1 and 81.2, the other provisions that point towards circumstances where there won't be invalidity. Again, the point I take from that is that Parliament's turned its mind to the question, and this court should be cautious about going beyond the circumstances Parliament has identified. Reason 3 is perhaps the one we haven't touched on so much so far. It's the centrality of the claim notice to the proper working of the Act. Because, my Lord Stevens, you asked what the purpose of the Act is. I suggest the proper question is, what's the purpose of the claim notice? Because that's what hasn't been complied with. The purpose of the claim notice is to start the statutory process of changing the landlord's position. It is the gateway to being able to give a counter notice, because without a claim notice you can't give a counter notice. It's the counter notice is itself critical, because that's what triggers the tribunal's jurisdiction. And the centrality of the claim notice stems from the wider point as well, not just to do with landlords knowing the claim is afoot, but to enable them to respond, because they're going to lose their management functions under their leases. They're going to lose powers to give consents. Well, sorry, it's not true. They're going to find their powers to give consents is altered. They're going to find their power to enforce covenants passes to an RTM company. And they're going to find that a whole range of statutory provisions change. The claim notice isn't just the start of the legal process in the sense of the litigation starting. It's what the landlord receives that tells him about the full extent of the changes that are about to apply to his land. And that's why it's central. The question, for my Lord Stevens, what's the policy of the Act? In my submission, that's the mistake Lord Justice Lewison made in Elim Court. Because as we'll see in a moment, he says, well, the policy of the Act is to enable leaseholders to acquire the management of their buildings, therefore I should interpret the whole legislation in that light. But the question is, what's the consequence of failure to give a claim notice? And the consequence is you can't give a counter notice, so you can't go to the FTT, so you don't know that all of your rights are being lost.
What happens if in the events that happen, you do get the right to go to the FTT because you're joined in the proceedings? So actually no prejudice is caused at all. I mean, that's the situation we have to consider, isn't it? I can see powerfully your argument in the case where you miss out on the opportunity to be heard as a result of the failure to serve a notice. It's not so obvious where it becomes a purely technical point.
Well, can I make two answers to that? One is I'd resist characterising it as purely technical.
Well, I know one never likes to do that as counsel because it's probably a bad move in submissions. I am shameless in taking technicalities when they're available, but you've seen from the pleadings, I hope, what's actually underpinning all this. And the respondent is quite frank about this in their written submissions. Presently, we derive a rent from these leases of around £30,000 a year. We think, and the respondent accepts this in their written materials, that one consequence of us losing control of this via the right to manage might be we lose our rent, because there'll be a way of the leaseholders being able to enjoy all the management benefits without having to pay for it. So to characterise all this as purely technical is, in my submission, to miss the reality of this.
But you can't rely on that fear as a ground for opposing the grant of the rights to the management company. It's a commercial reason why you want to fight, but it's not a weapon in the battle.
I agree it's not a ground for opposing it, but to pick on point, this is purely technical. This is not an arid debate for no purpose. That's what's driving all this. It's money is what's driving all this in the background. Secondly, of course, the only reason we got to join the FTT proceedings is because a different party happenstantially served a claim notice. The fact that a different party, counter notice, the fact that a different party served a notice and the tribunal was then organised enough to realise that we might want to be heard and join us, that doesn't save the failure to comply.
Why not?
Because Parliament, when you're identifying Parliament's intent, Parliament hasn't identified such individually esoteric considerations as driving the outcome.
Well, why hasn't it? I mean, if the full circumstances you need to ask was, would Parliament intend that in a situation where there was no claim notice served, but in the event no harm was done because it was brought to the attention of the tribunal and the party was joined, that in those circumstances that failure should defeat the whole claim and require the whole thing to be done again? And the answer to that might be no. Whereas if it hadn't come to the attention of the tribunal, the answer might be yes.
But that then opens up the whole problem that Lord Stevens and I were canvassing. If you don't get to the tribunal, actually when you're going to have this discussion, where you're going to have it, in what context, is so difficult to pin down. Because you can't...
But you did get to the tribunal.
Yeah, that's the point.
But the difficulty I see is that it's subjective. It is what actually has occurred rather than generic. And I have no views, haven't formed any view about whether what actually occurs can be taken into account as opposed to what generically might occur.
May I just... It's relevant to this. I mean, paragraph 23 of Synergy, which you said sort of encapsulates the approach, says the emphasis ought to be on the consequences of non-compliance. That seems to take you into what's happened in the particular case. And has it created real harm and real detriment or not?
Well, it may go that far, but what it also includes is the proper working of in this case, the proper working of the claim notice in the scheme. So what are the consequences of it? Well, the consequences are we were denied the right to serve the notice, we were denied the right, as of right, to be a party. I take the point. Of course, the reason I'm here is because we found out about the litigation and we applied to be joined and the tribunal rightly joined us. But that, I just suggest that when in the House of Lords they were talking about the consequences, there's two stages to this. The first is what's the consequence under the Act? And under the Act, we were deprived of valuable rights that Parliament said we were to have. Where this possibly comes in, this question of individual prejudice, in our case...
So can I just understand that submission? When you say deprived of valuable rights, weren't you able to take, in fact, every point that you could have taken in the tribunal if you'd been served with a notice? You were able to do all those things, weren't you?
I think I'd probably have to accept that's right, yes. But we were deprived of the right to serve the counter notice.
Well, you could have been, you might have been. So the question is whether a hypothetical situation which didn't in fact occur enables you to defeat the whole process.
Well, as to where this fits into my case, this focus on what actually happened and the facts driving the outcome fits in my ground too. So I'm happy to deal with this here. But at the moment, for ground one, I am submitting, and I'm perfectly happy to submit, that when you're identifying what Parliament intended, because it's a question of statutory interpretation, we're looking at what the Act, the importance the Act attaches to the failure in this case. And that can't be governed by what actually happens on the ground, because the Act doesn't concern itself with the outcome. The Act concerns itself with the process and the stages.
But that's to assume that Parliament couldn't have intended it to the consequence. It couldn't matter for that purpose as to what actually happens, and that may be an unreasonable intention to impute. A more reasonable intention may be that Parliament would have regarded it as critical to know whether it actually causes any harm or not.
So, and that argument would mean that Osman against Nat, page 621, paragraph 32, is incorrect, because there it says that prejudice caused by non-compliance on the particular facts of the case, and as Lord Sales indicates, Sanjay seems to suggest that you just look at the consequences.
you look at the statutory scheme, you interpret the statutory scheme, and you ask yourself, in light of that interpretation, what did Parliament intend? What it is asking itself in my submission is, what did you lose under this scheme of legislation? Whether or not you managed by happenstance to put yourself in the same or similar position because of good case management by a tribunal, in my submission doesn't go to what Parliament intended. This is now imputing a very broad brush approach to Parliament, where Parliament is saying, if this is the analysis, Parliament says in section 79(6)(a), you must serve these landlords with a claim notice. But ultimately, as long as by hook or by crook they know about the proceedings, it doesn't matter whether you serve them or not.
Well, that would be a fact-specific question as to whether it did cause potential some form of prejudice. And if it didn't on the actual facts, then why should you get a free win?
And the tenants would be taking a huge risk as to how things turned out if they didn't serve a notice. So
in this case, it may be their good fortune that it fact came to the attention. But if it hadn't, then it would have been fatal.
My answer to this is so happenstantial that the possibility that Parliament intended the outcome to be dependent upon sheer good luck as to what people discover at any given time is simply not consistent with the language of the Act.
Just on this, the individualised consequences being relevant, I mean, I read Synergy as turning very much on the individualised consequences in the particular circumstances as they happen to play out in that case.
If I may, my Lord.
Coming against your deadline.
All right, yeah.
Yes. All right. Just so you know, I'm not sure I had written it that way, and maybe we have to go away and look at it much more carefully. But it's what we're really talking about. This, the possible parliamentary intentions, none of which are written down, and I suppose therefore have to be implied because Parliament hasn't said what the consequence is going to be expressly, is either that it will always a failure to serve any landlord will always invalidate the process, or a failure to serve a landlord will only invalidate the process if the landlord who was not served complains about it, or a failure to serve a landlord will only invalidate the process if the landlord who was not served both complains about it and can show prejudice through having not been served. And those are all different possible parliamentary intentions as to consequences. And at the end of the day, we're having to construe what happens in a silence. Because if you follow Lord Hoffman and says, well, if there's a silence, it means nothing, it might suggest that there are no consequences of failure to comply with the provisions. And I don't suppose anybody thinks that's a terribly sensible place to end up.
I would simply say that obviously we lean towards the first of the three scenarios there, because we keep coming back to this. It's the statutory interpretation question. You look at section 79(6), you look at the Act as a whole, this scope for individualised discretion just isn't there. So the error, if I may, Lord Sales, that I respect this you're making, you're focusing on the intention, when Synergy talks about intention, but the starting point is the words. It's
the words ex hypothesi don't answer the question. There's a void there in terms of the words, and so we have to impute the intention. As
but we impute it from the words, from the structure of the Act. That's why, for all the good it's been doing me, that's why I've been trying to focus on the scenarios where Parliament has identified what can be saved, because that does show you what Parliament's intention was. I'm conscious of the time. I'll deal largely now by page references. I need to deal with why Ealing Court is wrong, because, of course, it was binding on the courts below, but not binding on you. The answer, if I may, is just for your notes. It's paragraph 73 in Lord Justice Lewison's judgment. He asked himself the wrong question. The question isn't what's the policy of the Act. The question is what is the consequence of failure to serve a claim notice.
I'm so sorry, do you have the page number just for that?
It starts at 558.
Thank you very much.
But it's paragraph 73.
579.
It's his reasoning. It is the wrong question he asks himself. Secondly, then on ground 2, this assumes that ground 1 has not got anywhere, and there are some circumstances in which a failure to serve in accordance with section 79(6)(a) would not be fatal, and it's very narrow. I said, my Lord Briggs, I'll take you to the FTT decisions and the upper tribunal decisions to say it's a finding. I'll give you the reference. Page 138 is the extract from the FTT decision, where they reject my argument that they should have found it was intentional, and they say it was inadvertent. The upper tribunal, it's page 189, paragraph 49. Judge Cook allows my appeal on that point, but because of Elim, it gets me nowhere. So it's a finding of an intentional decision not to comply. And I end with, if there is provision in an act saving a failure to comply, an intentional decision not to carry out Parliament's instructions is not one that any reasonable Parliament would have expected to be waived. My Lords, unless I can be of any further assistance, I've eaten 5 minutes into Mr. Rainey's, but I hope you'll forgive me.
Well, you did start slightly late as well, and that was our fault. Yes, Mr. Rainey. Mr. Rainey, can I just say this? I mean, we've obviously read your very scholarly and helpful written intervention, and we understand the wider reasons why you're here. But I think we would be most assisted if you could focus quite sharply on the actual point we have to decide on this provision of this Act.
I shall do my best, my Lord. I was going to say that the nub of this appeared potentially to be the difference between my Lord Legate's point about concentrating on what had actually happened to this particular appellant, and Nat and Osman, which would say you can't look at that, because we set out in our application to intervene a number of possibilities as to where the court might go in terms of the general principle. But all paths really lead back to the difference between Nat and Osman and sonergy. So Nat and Osman says that it's an application of sonergy, but with respect, it seems to be different in two fundamental respects, because it divides the cases into two, and it says there are two categories. One is effectively public law, criminal, administrative law, and so on, and category 2 is private law / property rights. And it says, and it's very explicit in Nat and Osman, it says the difference is that in the category 2 case, first of all, substantial compliance is never enough, whereas substantial compliance may be enough, according to sonergy and ex parte Gianthian, in a public law context. And secondly, it says that although you can look at what's called generic prejudice, you can't look at actual or subjective prejudice. So you can look at, apparently, according to Elim Court, for instance, you can look at the terms of the lease of the intermediate landlord, but you should close your eyes to the fact that the directors of the intermediate landlord and the freeholder are the same, and therefore that if you've served the freeholder, which is what happened in Lexham Court, the freeholder, the intermediate landlord will know because its directors are common, but you shut your eyes to that, according to Nat and Osman. And we respectfully suggest that fundamentally Nat and Osman went wrong. There's just one category of case. It's sonergy, and it's always sonergy. And in fact, my learned friend, Mr. Bates, effectively said he's relying on sonergy. Now, if that is correct, then with respect, there was a wrong turning in Nat and Osman, and you can look at, as my Lord Legate said, you can look at the actual consequences for the actual party. And in terms of the opposite...
But that would be, wouldn't it, through a prism which, if you like, implies in an imputed intentional rubric that says, and a failure to comply with this may be relied on for invalidating the process by somebody who suffered prejudice.
Yes. And it's the focus, perhaps the best way to put the question is that the cases tend to talk about the validity or invalidity of a notice, but that's not actually the test. The question is whether it is the subsequent step is invalidated by the procedural failure at a previous stage. And that's clear from Sonergy. And of course, it needn't be a notice. It could be a failure to meet a time limit. It can be the content of a notice. It can be the service of a notice. It can be giving notice to a statutory body like the Financial Conduct Authority in an administration order case. There are a wide variety of missteps which can be made, and logically the same principles apply to all of them. And the focus is on the validity or otherwise of the subsequent step. And if one looks at it that way, that's why the imputed intention of Parliament would be that you can take into account the consequences of the previous misstep, because that will inform the fair intention to be imputed to Parliament as to whether the subsequent step should be invalidated. And that is the approach which is adopted in the public law type cases. I haven't obviously got time to develop it, but in our written submissions we pointed to the line of authorities about appointment of administrators out of court. In those cases, they apply, or the better view appears to be they apply what you might call full sonergy. They treat it as category 1. You look at the actual consequences, the actual prejudice and substantiality of compliance. We also included the rating case of
and sorry, just on that, and that'll have property consequences, presumably, appointing administrators out of court.
Yes.
Was there to administer property, presumably?
Well, it's also a species of one of the other points we make, which is it's actually hard to see whether it really is category 1 or category 2, because it doesn't fall neatly into either of the Nat and Osmond categories.
And it's hard to see why the difference in itself matters. It's surely the particular interest at stake that's important, and that may vary hugely within what is put in category 1 or 2.
Well, a more fundamental way, perhaps, to put it is that there can't be any logical distinction in principle, because if, as is common ground, Nat and Osmond is supposed to be applying the test, the underlying test of asking what is the imputed intention of Parliament as to the consequence of the procedural failure, well, why would Parliament's intention in category 1 be that substantial compliance might be sufficient, but it's never sufficient in category 2? Why would Parliament's intention in a criminal case be that you can look at the actual consequences, the actual prejudice, but as soon as you say it's a property case, you have to shut your mind to it? They're all statutes.
If anything, you might think it would go the other way round. I mean, if so far as one's talking about the freedom of the subject in the sentencing situation. Anyway, it's difficult to fasten in the abstract upon particular interests and say, well, these must always outrank other interests and lead to a different legal consequence.
We'll be maintaining a sort of strictly sort of neutral and helpful position. There could be reasons why you might say that it's different in the particular context of a criminal statute, because, for example, that there's a strong public interest in validating, for instance, confiscation orders and so on, and you might say that there's a much weaker public interest in validating a claim to take one person's property from another. So that might be a difference, but it's just an application of sonergy to the particular factual and statutory context. Also, in criminal cases, it might be observed that there are other potential escape valves, for example, dismissing a claim or an application or a prosecution on the basis of an abusive process. And those, I think technically the civil courts can dismiss things as an abusive process, but it's not developed in the same way. So those may be particular differences which might lead to different outcomes in property cases. But the core point ought to be, in our respectful submission, that it's sonergy. And the Nat and Osmond took this wrong turning by categorising property cases into a narrower bracket. From the point of view of the Association of Leasehold Enfranchisement Practitioners, the difficulty with narrowing anything down is that, as you've now seen, right to manage is good example of particularly complicated landlord and tenant sort of statute. But there are as many landlord notices in these statutes as there are tenant notices. 7 Strathray Gardens is an example of where the landlord had to be rescued from failing to mention that there was, failing to say whether or not there was an estate management scheme. So the same principles have to apply, and as we've said in our written submissions, the trouble with certainty is it tends to be at the risk of inflexibility of outcome. What practitioners really want, we respectfully suggest, is predictability, and the Sonergy test allows a predictable outcome in the sense that if you can look at the actual circumstances, you will have a fairly good idea of whether or not you're likely to succeed or not. Because if it is obvious that there's no actual prejudice, then one would think the imputed...
How's that dispute played out? So take this case, and there was no notice served on the intermediate landlord, therefore no counter notice by him. If there was no other counter notice, there would be an automatic transfer of management responsibilities. The tenants would have to pay their service charges to the new RTM company. But the intermediate landlord might commence a High Court proceedings seeking a declaration, saying I was prejudiced. And then you would have a dispute about the facts there to see whether or not there was or wasn't prejudice to the landlord, to the intermediate landlord. In the meantime, of course, the tenants don't know who to pay, what to do. How do you solve that particular problem?
There is always the potential in a, what one might call a marginal case, for having that kind of argument. It doesn't necessarily need to play out in the High Court. It could even play out in the tribunal if someone said, well, these service charges have not been reasonably incurred because you are not the landlord, you are the RTM company, and vice versa. It's fair to say that if there is, in general terms, I would accept, if there is a risk that there is significant uncertainty if a particular step is not followed, then that might, at the first stage of looking at the overall statutory scheme, that might be a pointer to saying, well, this is an essential step. But the particular point in the RTM situation, which has been taken in Ellum and is taken in this case, is that on the facts of this case, the only point that the appellant has got is that they weren't served. The point of a counter notice is to say that there's a reason why RTM can't be acquired. It's a rather perverse notion that the argument is, well, I lost the right to give a counter notice. There's nothing I could have said, but because I didn't get served in the first place, I now have an argument, and so my argument is that I didn't get a chance to say nothing. And that's, I would respectfully submit, it isn't an attractive landing point. But it is potentially the consequence, certainly if what's being called the Ellum Court exception is narrowed, it is where you tend to end up because you can't look at the fact that there wasn't any particular prejudice or that they were at the tribunal. But you can apparently, and again, slightly jumping to a further point about the difficulties with Nat and Osman moving away from Sonergy, is how do you distinguish between what is generic prejudice and what is actual prejudice? Because if you are looking at the terms of the intermediate landlord's lease to realise that they have no management responsibilities and therefore that they are effectively unaffected by RTM, are you not looking at something which is fact-specific already?
I've always found that a very odd concept. Where you have a whole building with lots and lots of flats, there are lots of stakeholders in the building who potentially will be, whether or not they personally have management responsibilities, may be adversely affected by a change in manager wrought by the triggering of a statutory scheme. And I don't see why the prejudice is just confined to where your own management rights are being taken away.
The reason that
the point is that a contractual structure which you agreed is being varied without your consent on statutory grounds, and the regime gives you a leg up to argue that one of those, if you can, you say they can't in this case, that one of those grounds is not satisfied.
I think the difference is whether or not there is a reason for saying that RTM is not capable of being acquired.
Yes.
If there is a potential ground, then yes.
And it wouldn't matter if there was a potential ground, would it, that the particular complainant wasn't complaining about actually having management authority or rights taken away, but simply having one manager substituted for another with whom he was perfectly content?
I wouldn't respectfully go that far, because you could argue that perhaps a minority of qualifying tenants who haven't joined the RTM company are quite happy with the existing landlord and don't want the RTM company. But that's implicit in the statutory scheme. Parliament has said if the requisite majority forms a company and subject to the consequences.
I'm not suggesting the minority have any vested right. If the statutory conditions for the RTM company are satisfied, well, then it goes ahead, as I understand it.
Yes.
But one has to ask why Parliament cast the net so wide in terms of those who had to be served with a claim notice. They could have cast the net only, as it were, saying you must serve everybody who has a management responsibility that would be taken away by the vesting of those rights in the RTM.
I would respectfully submit what Parliament needed to do was to identify the parties who might be affected by it, which is likely to be landlord parties, third parties to leases like management companies and management trustees, and 1987 Act managers, which is very broadly the categories of people who have to be served. Now, within those categories, you will get intermediate leases which have management responsibilities, but you also get ones which don't.
Yeah.
And this is the consequences question I would respectfully submit. There isn't anything conceptually difficult about saying, well, Parliament intended, because it said so, that everybody is served. That's what the Act says. If you didn't serve everyone, then you haven't followed the procedure. But when asking the question, well, does that mean that all subsequent steps, the acquisition of RTM, are invalidated? Doesn't mean that you can close your eyes to the fact that the particular person who's not been served actually has no management responsibilities and is effectively a passive observer to the transfer from the head landlord to the RTM company. I would submit you can take that into account in determining that RTM is valid or validly acquired. And that would be the application of Sonergy and Janthe. And indeed, even on Nat and Osman, unless you narrow it down, looking at the lease itself, Elling Court and so on, says, well, that's a kind of generic prejudice point. Query that, because I respectfully say it's difficult to see where the boundary lies between generic and actual prejudice. But nevertheless, in this case and in Elling Court, the court was prepared to look at the terms of the lease, say there's no actual management responsibility, therefore the failure to serve does not invalidate the overall process. Given the shortness of time available to develop my submissions, I wonder if I could just add one or two sort of specific points. At the end of our written submissions, we respectfully disagree with the proposition that if there is a saving provision for one thing in the Act, you infer that everything else is a fatal defect. And respectfully agree with my Lord Legate, that simply doesn't follow. It's a non sequitur. It is, however, what is said in Nat and Osman at paragraph 37, and that's wrong. And you can see it two ways. There are also provisions in some acts where it is clear that failure to follow, usually a time limit, is fatal. The 1993 Act has deemed withdrawal provisions if you don't do something on time. You don't apply the opposite analysis and say, well, because Parliament said that that's fatal, therefore everything else is not. It just means that between the two extremes, there is a middle ground where Parliament has left it to the good sense of the courts applying sonergy. And it's logical. Parliament would identify the extremes. It would identify things which it considers are so important that it's worth saying in the statute that if you don't do it, it's fatal, and things which are so unimportant that it's worth saying that failure to comply is never fatal, with a very large playing field in between, probably 95% of the other cases where it may or may not be fatal, depending on the circumstances. And in the additional authority that we identified, the National and Grindley's Bank and Philabji case, which is in the intervener's revised bundle.
Yes. Thank you for that, by the way.
I beg pardon?
Thank you for revising it at short notice.
We did our best, my lord, and I think thanks to my solicitors rather than...
Well, of course, that's what I meant.
Indeed.
I don't suppose you did it personally.
No, I didn't. In that case...
So which page is of your bundle?
The page to jump to is page 646.
646.
Yeah.
Which is so my computer obviously has chosen this moment. So at page 646, it's in the opinion of Lord Pearson, and he says at the very bottom of the page, he says the argument that there's a contrast between the limited invalidity imposed by the surrounding sections and a supposed total invalidity imposed by section 15 breaks down because it involves a petitio principii. Section 15 does not, by its express terms, impose any invalidity. The invalidity is only implied. The extent of it has to be inferred from, inter alia, the surrounding sections. And he then goes further. He says the natural inference from them is that the invalidity is limited. So that is Lord Pearson effectively rejecting the argument that if you've got a saving provision in one section, you infer that it's fatal in the other. And that was the other point we made about that is that it's a private law case, what you might call category 2. I think,
but it's nowhere near subjective prejudice.
It doesn't. It's not a case I'm addressing on the subjective prejudice point.
No.
The second case that we added was just the fruit of trying to find a very clear case from another jurisdiction, which was what you might call a boring landlord and tenant type case where subjective prejudice was taken into account, and we latterly found it in the Rauti against Tamaki case in the New Zealand High Court, which is at the very end of the bundle. And if you allow me to refer you to the relevant page there, page 656 is where it begins. And you can see...
Which paragraph?
Well, paragraph 1 on page 657 says it's Residential Tenancies Act of 1986 in New Zealand. Paragraph 3 in the 4th and 5th lines shows that there's an argument about the validity of the notice of termination. And then if one jumps to paragraph 23 on page 665, Justice Lang finds there's a non-compliance with section 43 of that act, and then he applies what is the Ellesmere case, which is sonergy. He says that's not the end of the matter at paragraph 24. He then, at 25, applies the sonergy test, which is now Tannadice in the New Zealand Supreme Court. And then this is the crucial point, at 29, in his reasons for finding that the notice seeking possession is valid, paragraph 29 on page 667, he says the tenant is well aware of the true situation. So there's a clear finding in another jurisdiction of simply applying what you might call the full sonergy test to a property notice. And we did point out that actually before Nat and Osman, there were at least 2 cases in RTM where ex parte Gianthian was applied. They're both in the main bundle. They're the Sinclair Gardens and Oak Investments, and the President, Sir Keith Lindblom's decision in Avon Freeholds and Regent RTM. Both those cases apply.
What are the page numbers of the case?
One moment, my lord. Sinclair Gardens and Oak is page 693 of the main bundle. Avon and Regent Court is at 496. And in terms of the difficulty in splitting cases up into their different categories, I would also point out that in Nat and Osman, there's quite a lot of reference to Newbold and the Coal Authority. And Nat and Osman says that Newbold is a Category 2 case, a property case. But query that, because what Newbold actually is, it's a statutory compensation claim against the Coal Authority under statute. It's not a property notice at all. And in fact, Sir Stanley Burnton at paragraph 68 actually says it. He says it's not a property right case. Logically, Newbold might be thought to fall into Category 1. But the Court of Appeal, having decided there were these two categories, thought it was in Category 2.
Can I trouble you for the page number of that quotation?
The page number of the relevant passage in bold is Sir Stanley Burnton is at page, it's 645 in the main bundle.
Oh, it's the main bundle.
Yes.
Yeah.
Sir Stanley Burnton and Lord Justice Longmore both apply an adequate compliance test to the validity of the notice in Newbold, which would be contrary to Nat and Osman saying that adequate or substantial compliance is never enough.
Well, that goes round in a circle, doesn't it? Because you say it was wrongly categorised as a Category 2 case anyway.
Yes, one way or another, there's an inconsistency in it. If it's in Cat 2, it shouldn't have used substantial compliance.
Right.
Or the alternative is it's actually in Category 1. It's wrongly categorised. I think that I've exhausted.
Well, thank you very much, Mr. Trainee. We'll resume at 2 o'clock.